when is somebody in custody for the purpose of Miranda warnings? What exactly does in custody mean? Does that only apply to an interrogation after a formal arrest? Well, what if you're questioned in your bedroom at 4 a.m. surrounded by officers? What if you're in a police station, but you went there voluntarily? What if you're interviewed as a witness, but the police actually suspect that you are the one that committed the crime? Today, we're covering 7 different cases that are all extremely important for you to understand when you have to apply Miranda based on somebody being determined to be in custody. It's important that you stay and watch all 7 because all 7 are very important to how you do your job.
And with that, we welcome you to the Cuffs and Case Law podcast, where we read case law so you don't have to. 2 quick notes before we get started here. We've switched our software that we're recording on, so this is going to look and sound different.
Well, we hope so.
We'll work on it.
Yeah.
And we keep forgetting to set up the show, which is Nate does all the research for these cases, and he tells me absolutely nothing going into this. So you're seeing my genuine reactions.
Yep. Yeah, he knows nothing about this. He does all the tech stuff, and I do the case law stuff. So last episode, we covered...
you forget to mention that we are not lawyers.
Oh, you're absolutely right.
Recording
that part's
the
important.
Yep.
All right. So I'm Nate. That's Dave. And we're not attorneys. We're cops. So in last episode, we covered Miranda v. Arizona and the now ubiquitous Miranda warnings.
Ubiquitous. We're starting early with the big names or words.
Yes, we are. Which stem from that case. So we learned in Miranda that Miranda warnings absolutely have to be given to a suspect during custodial interrogation by the police. So you have to have both those factors, right? They have to be in custody and you have to be interrogating them. So a huge portion of that is, what does in custody mean, right?
Which I'm pretty sure I asked you in the episode. I said, did they define this? And we glossed over it.
We did, and intentionally, because I
knew that this was going to be the case.
I knew that this was going to be the next one. It's such, I think, an important thing to follow Miranda, because if you don't understand what in custody means, then you don't understand when to apply Miranda. You know that you have to, right? But you don't know when you need to actually apply it.
I think as a police officer, you also need to know that fine line, because if you Mirandize everyone you talk to, then no one's going to talk to you.
Yeah, and you don't have to. The Supreme Court flat out said in Miranda v. Arizona, like, hey, this doesn't preclude you from talking to people, because you have to talk to people for your job, right? It's only for custodial interrogations.
Well, imagine you as a robot walk up to every single person. You have to remain silent.
Yeah,
They're
exactly.
Like, all right.
So the interrogation part's super easy, right? If you are asking questions that are likely to elicit an incriminating response, you're interrogating that person. So that part's pretty easy. But what is custody? So that's what we're talking about today. Again, we're going over 7 different cases. So there's a lot to cover here, but each case is different, and each case is important to give you a really good conceptual understanding of if that person that you're dealing with is in custody, and that way you know, hey, if I'm going to ask any incriminating questions, I need to advise them of their Miranda warnings first.
Well, if you thought that this was going to be brief, you're wrong.
So wrong, dude. 7 cases. 7 is a lot. It's a lot of cases. So I figure we probably shouldn't waste any more time. We want to get into
Let's
this.
Go.
Right.
Number 1. Nope.
No,
we got to do setup. We got to lay the groundwork.
Yeah, well,
that's a theme.
Well, it is a theme, but we're actually not going to do that.
Same sheet of music as you said last episode.
Nice. What I need to say is I have no idea how to pronounce so many of these names. So, dear listener, I'm sorry if I butcher this. I'm going to try the best I can.
I'll work out in post if I can figure it out, but there's no way I would know
either.
either.
Going to spell it phonetically on the screen right here.
Here's how, because that's very important. You can't quote the case on the stand if you don't know how to pronounce it.
Yeah, it's going to be rough. Case number 1. We're going to 1969.
Nice.
Yeah, I knew you'd appreciate that.
That's a great way to start.
And this case is...
I'm locked in now.
Orozco v. Texas. And
you nailed that one.
Yeah, I don't think I did. I think you have to roll your R in this one. But this case involves the arrest of Reyes Arias Orozco, who was convicted.
That's tough to say. I'll give you that.
Yeah. I'm not going to say it much anymore. It's just going to be Orozco from here on out.
Okay.
He was convicted in the criminal court of Dallas County, Texas, of murder without malice.
Not robbery this time?
No.
I started with murder.
I am fairly certain none of these 7 are robbery, which is super strange for us here on Cuffs and Case Law.
Yeah, it was kind of hilarious to listen to back.
The last one was, hilarious. So he was convicted of murder without malice, and he was sentenced to serve in the state prison not less than 2, which seems light, but not more than 10, also seems light, years.
For a murder.
Yeah.
Hmm.
So, little background on the case here. The evidence introduced at the trial showed that Orozco and the decedent had quarreled outside of the El Farleto Cafe in Dallas shortly before midnight on the date of the shooting. So the decedent had allegedly spoken to Orozco's female companion.
That'll do it every time.
Whilst inside of the restaurant. So these two boys take it outside, as you do in Texas. And
he's defending his lady's honor.
Yeah.
Or the right to keep him as their girlfriend or whatever.
In the heat of the quarrel.
Yep.
The decedent is said to have beaten Orozco about the face. So he's punched him in the face. And then he called him a term that I'm not going to say, but it is a slur for an Hispanic individual, is what he called him. Shortly thereafter, a shot was fired.
Which elicited a response.
It did, yes. A shot was fired, and that killed the deceased. So Orozco left this scene and returned to his boarding house. We got quarrels in boarding houses in this case.
I don't think it's working, but that would make sense why he's at a boarding house.
He's at a boarding house, and he went back home to sleep. So at about 4 a.m., they had already identified him.
Wow.
And so 4 police officers show up at his boarding house, and they were admitted entrance by an unidentified woman. And she said, yep, Mr. Orozco is asleep in his bedroom. So all 4 officers go into this bedroom and wake this dude up at 4 a.m.
That seems like poor tactics.
Yeah. From the moment he gave his name, according to the testimony of one of the officers, Orozco was not free to go where he pleased and was, quote, under arrest.
Yeah, if you're busting into his bedroom,
so
I would say they probably should have had a warrant.
Yeah, and they straight up asked the officers, they had consent to get in.
Oh, well.
But they straight up asked one of the officers, like, hey, is this dude free to go? And the officer's like, nah, he was under arrest. That's key.
That will play a factor.
Yeah, so the officers asked him if he had been at the El Farleto restaurant and at night, and he's like, yeah. So
I assume they've never read him his Miranda rights before this.
No. Oh, man. No. So they were like, okay, cool. You were at the restaurant. Great. Do you have a pistol? And he's like, yeah. And I'm like, okay. Where is it? He didn't answer. So they asked again, and they said, no, seriously, where's this pistol? And as all normal, responsible citizens and gun owners do, he was like, well, obviously it's in the washing machine in the back room of the boarding house.
I have to clear the blood off of it.
So they go to the washing machine. They find the gun. They run ballistic tests on the gun. And believe it or not, that was the gun that fired the fatal shot. Yeah. So at his trial, the trial court allowed one of the officers to relate the statements that were made by Orozco concerning the gun and his presence at the scene of the crime. So the Court of Criminal Appeals, he was convicted, believe it or not.
Yeah.
So, and also, believe it or not, he appealed. And the Court of Criminal Appeals of Texas affirmed the conviction, rejecting the claim that the confession was in violation of the Fifth Amendment to the United States Constitution.
Didn't Miranda just get posted?
Yeah, 3 years earlier. Yeah, it was pretty fresh. But he's not in handcuffs. He's not at a police station, right? So
he didn't ask for a lawyer.
He didn't ask for a lawyer, right? So, and they're like, dude, this guy's laying in his own bed in his own house.
Sleeping. He doesn't care.
Yeah. They're like,
he's comfortable.
Spoiler alert, the state of Texas is like, there is no way this dude's in custody right now. He's literally sitting in his own bed in his boarding house. He's not at a police station. He's not in handcuffs. I didn't arrest him. I didn't tell him he was under arrest. I didn't put him in handcuffs. There's no way that he's in custody. So that's the argument that it makes back and forth up during the appeals process. And it gets all the way to the United States Supreme Court, who grants
certiorari.
Certiorari. All right.
Which is what you granted us at the start of this episode.
Oh, nice. I
thought about that earlier today.
All right. So the Supreme Court starts by saying, well, the trial testimony clearly shows that the officers questioned him about incriminating facts without first informing him of his right to remain silent, his right to have an attorney, to consult with an attorney prior to any questioning, his right to have a lawyer appointed to him, to assist him, and that one could be appointed to him at no cost, right? So that's all settled. We're not arguing that. That's pretty clear. So the Texas Court of Criminal Appeals held that the admission of testimony concerning the statements that the petitioner, Orozco, had made without Miranda warnings was not precluded by Miranda. The Supreme Court, however, said, we disagree.
Because we just covered this.
And hold that the use of these admissions obtained in the absence of the required warnings was, quote, a flat violation of the self-incrimination clause of the Fifth Amendment as construed in Miranda. The state has argued that since he was interrogated in his own bed in familiar surroundings, our Miranda holding should not apply. The Supreme Court says, it's true that the court did say in Miranda that compulsion to speak in an isolated setting of a police station may well be greater than in courts or other official investigations, if you recall that, where there are often impartial observers to guard against intimidation or trickery. But the opinion iterated and reiterated the absolute necessity for officers interrogating people, quote, in custody to give the described warnings. So that's what they're hammering home on, right? So according to one officer's testimony, Orozco was under arrest and not free to leave when he was questioned in his bedroom in the earlier hours of the morning.
Did the other three say anything, or did it only cover one?
Yeah, it's just the one guy. Yeah. But
they're like, we only need to talk to one of you.
Yeah. So the court said the Miranda opinion declared that the warnings were required when the person being interrogated was in custody at the station or otherwise deprived of his freedom of action in any significant way.
That's when I asked you, did they define significant? And you said no.
But they did in Orozco,
here we are.
right?
And that's why we have evolving case law. And that's why we have to cover. That's why we're going to have infinite episodes.
Yeah,
there's always different variables.
Yeah. So if you like this, please like this. Please subscribe. Please keep watching.
It's a great time to do that. Thank you.
Thank you. You
Click
set
the
up
button
the
down here.
Where'd you point?
Right in the middle. I'm hoping I put a graphic. Yep, right there.
Here. All right.
Please subscribe and like. It helps us reach more officers.
Yeah, it really does.
Or citizens that are interested in learning their rights.
Absolutely. So, again, the Supreme Court focused on the back half of that Miranda conclusion that if people are otherwise deprived of their freedom of action in any significant way, then you also have to give them Miranda warnings.
Significant.
So, in this case, they're like, look, you put 4 cops in a bedroom at 4 a.m. and those
woke the man up.
And those cops said that this dude was not free to go. You are depriving him.
One of them did.
Well, true. But you are depriving him of his freedom of action in a pretty significant way. So you should have read him his Miranda warnings.
They didn't walk in and said, you're free to leave, but also we're waking you up.
Yeah, you're free to leave, but there's 4 of us in your bedroom.
And we're in front of the door.
So this is important, too, when it comes to Orozco. The Supreme Court said, we do not expand or extend to the slightest extent our Miranda decision. We do adhere to our well-considered holding in that case and therefore reverse the conviction. So that brings up the first of many, many important factors that we're gonna talk about here, and one of those is the setting, right? So if you got
the context matters.
The context super matters, especially when
otherwise you let murderers go.
Yes. Well, I mean, they had a lot of evidence. But
they reversed his conviction.
They did reverse the conviction. The setting absolutely matters. If you have 4 cops surrounding somebody in their bedroom at 4 a.m., that person's probably, their freedom of movement is probably significantly altered.
Yep.
So, in that case, they ruled that, hey, you have to give Miranda warnings before you're asking incriminating questions. So, all right.
That one seems pretty clear. I can follow that one.
That one's pretty good, right? Next one is Oregon versus Mathiason. This case comes from...
Are you sure?
I'm pretty sure. I wanted to say Mathiason, but it's I'm pretty sure it's Mathiason.
All right.
Anyways, this case comes from 1977, so we fast forward 8 years. And this involves the arrest of Carl, probably Mathiason. That's his name. So he was convicted of first-degree burglary after a bench trial in which his confession was critical to the state's case. So an officer of the state police in Oregon was investigating a theft at a residence near Pendleton, Oregon. And he asked the lady of the house. That's all it says. Lady of the house.
The lady of the house.
The lady of the house, which had been burglarized, if she suspected anyone. And she said, well, Mathiason is the only person that I can think of. He's a parolee and a close associate of my son.
Mm.
So this officer tried to contact Mathiason on 3 or 4 occasions with no success. So about 25 days after this burglary happened, the officer leaves his card on Mathiason's apartment with a note asking him to call.
Call me, please.
Because, quote, I would like to discuss something with you.
Discuss something.
Believe it or not, the next day, Mathiason called him. And the officer was like, hey, dude, where would it be convenient for us to meet? Mathiason's like, I don't care, man. So the officer said, all right, well, why don't you meet us at the state patrol office in about an hour and a half, and we can talk there. And Mathiason says, cool. The patrol office was like 2 blocks from this guy's apartment.
Well, that's quite convenient.
Yeah, it worked out well. So the officer met Mathiason in the hallway, shook his hands, took him back into an office, and he was told specifically that he was not under arrest. The door was closed, and the two sat across a desk from each other. And their dispatch center was close, so the police radio in another room was able to be heard. And the officer told Mathiason he wanted to talk to him about a burglary, and that his truthfulness would possibly be considered by the district attorney or the judge.
Your statements might be considered.
So the officer...
I can't guarantee I'm not them.
The officer further advised that the police believed Mathiason was involved in the burglary, and falsely, they told him that his fingerprints were found at the scene. They had not been, but they tell Mathiason, "Hey, man, we think you're involved in this burglary, and we got your fingerprints at the scene."
Since there was a parolee, had already been taken.
Yeah. So Mathiason sat there for a few minutes, and then he said, "Yeah, I took the property." So this occurred within 5 minutes of this dude showing up at the office.
And the officer detective's like, cha-ching.
Yeah.
Got
him. So within 5 minutes, he says, yeah, I took the property. So then the officer puts a pause on things. He then advises Mathiason of his Miranda rights and took a full taped confession afterward.
All right.
At the end of the taped confession, the officer told Mathiason that he wasn't arresting him at that time. He was released to go about his job and return to his family.
Just indict him later.
Mm-hmm. The officer said he was referring the case to the district attorney to determine whether or not criminal charges were going to be brought.
Because Mathiason was so honest after a few minutes.
Yeah. So all in all, Mathiason shows up at like 5 p.m. He's out of the office at 5:30.
He's like,
in and out.
All right. See?
So at the trial, he moved to suppress the confession as the fruit of questioning by the police not preceded by the warnings required in Miranda.
Fruit of a poisonous warning. Or
That's
lack
a throwback. It's been several episodes.
I know. I haven't gotten it in there.
Oh, yeah. The trial court, however, refused to exclude the confession because it found that Mathiason was not in custody at the time of the confession. Yeah, conviction.
At the conviction, he probably wasn't.
Dave was definitely in custody.
Okay.
Then, yeah. But so they said, no, we're going to include your confession because you were not in custody at the time that you made that confession. So the Oregon...
We even read you your rights.
Yeah. The Oregon Court of Appeals affirmed his conviction, but on his petition for review in the Supreme Court of the state of Oregon, that court, by a divided vote, reversed the conviction.
Did anyone abstain from that vote?
No.
Okay.
It was found that although Mathiason has not been arrested or otherwise formally detained, the interrogation took place in a coercive environment of the sort to which Miranda was intended to apply. So the state appeals all the way up to the United States Supreme Court, and they grant
certiorari.
All right. So what do you think? What do you think about this case? With what you know thus far, do you think that the Oregon Court of Appeals got it right, or the Supreme Court of Oregon got it right?
This one's a little bit better because he actually reads him Miranda, and he told him he wasn't under arrest.
Mm-hmm.
So from my education background, it's would a reasonable person believe they were free to go?
Oh, man, that's a catchphrase and a half. You just summed up this hour and 30 minutes of cuffs and case law. So you're saying it's probably good to go?
It's a tough line there because I'm trying to think of the time period and how restrictive they would have been.
1977.
Yeah. If I had to make a decision, unlike the one Justice and Miranda,
mm-hmm.
I would say they would have said that was good to go. They liked most of, or all of that.
You're 100% right. Supreme Court said
They didn't lock a door or anything
nope.
in terms of the context, and he also freaking released him.
Exactly.
Not that that should matter to the first part of it, but
shouldn't, but does. Yep. No, you hit the nail on the head, man. So the United States Supreme Court said in the present case, there is no indication that the questioning took place in a context where Mathiason's freedom to depart was restricted in any way. He came voluntarily to the police station, where he was immediately informed that he was not under arrest. And then at the close of the half-hour interview, he did, in fact, leave the police station without any hindrance.
never had handcuffs on, nothing.
Nothing.
Never told
Nope.
he was under arrest. Nothing.
Exactly. Supreme Court said
detained.
it is clear from these facts that Mathiason was not in custody or otherwise deprived of his freedom of action in any significant way. Such a non-custodial situation is not converted to one in which Miranda implies simply because a reviewing court concludes that even in the absence of any formal arrest or restraint of freedom of movement, the questioning took place in a coercive environment. So they're saying just because you talk to the dude at the police station does not trigger Miranda.
Yeah.
Right? It has to be in custody interrogation. And the facts of this case, they're like, there's no reason for us to consider that Mathiason was in custody. So they said, yep, this is good to go. Any interview of one suspected of a crime by a police officer will have coercive aspects to it, simply by the virtue that the police officer is part of the law enforcement system, right?
Adversary system, as you said last time.
Oh, man, it's an adversary system in which may ultimately cause the suspect to be charged with a crime, but police officers are not required to administer Miranda warnings to everyone whom they question. They reiterated that again. Nor is the requirement of warnings to be imposed simply because the questioning takes place in a station house, or because the questioned person is the one whom the police suspect. So they thought it was him. It's at the police station, but they're like, no, he was not in custody. Miranda warnings are only required where there has been such a restriction on a person's freedom as to render him, quote, in custody. The officer's false statement about having discovered Mathiason's fingerprints at the scene was found by the Supreme Court of Oregon to be another circumstance contributing to the coercive environment, which made, in their minds, the Miranda rationale applicable. The Supreme Court said, whatever relevance this fact may have to other issues in the case, quote, it has nothing to do with whether Mathiason was in custody for purposes of the Miranda rule. So they're like,
just because of what he said.
Just because of what he said doesn't change the fact of he's not in custody.
Yeah. Because I guess no matter what evidence you're telling them, it wouldn't change your thought of being free to leave or not, is what they're getting at.
Yeah. And that's why it's important that they actually let him leave.
Yeah.
Right? Because at no point in time did this ever become a custodial thing. Right? So we'll get to that here in a different case. But if it starts non-custodial, but then becomes custodial at some point, well, now we're triggering Miranda. Spoiler alert.
But he covered himself.
Start to finish. And the Supreme Court said, yep, Supreme Court says, you're good to go.
They said, thank you for getting this right.
Yeah, they're like, it's about time.
We'll reward you with a conviction.
Yes. All right.
This is not affirm a denial.
No, which is one of our favorite things. All right. So we talked about this next case 3 times on the Cuffs and Case Law podcast.
3 strikes, you're out.
And I
third time's the charm.
I initially intended,
Three's company.
Man, look at you. You're just chock full of them. I initially,
distract you.
It's working. I initially wanted this to be its own standalone episode.
Yep.
But it makes so much more sense in this context. So we're just doing it now. And that is the case of Berkemer v. McCarty from 1984. So this case involves the arrest of Richard McCarty by the Ohio State Highway Patrol. Do you say the Ohio State Highway Patrol like you say the Ohio State University? Do you know? I'm going to say
I don't know.
I'm going to say the Ohio State Highway Patrol. They're also called OSP. So if I say OSP, that's what I'm talking about. On the evening of March 31st in 1980, Trooper Williams of the Ohio State Highway Patrol observed McCarty's car weaving in and out of the lane on Interstate Highway 270.
I don't think the troopers like that.
They don't like it. No. So he followed him for 2 miles, and then he stopped him and asked him to get out of the vehicle.
Just like that.
Yeah.
Get out.
Get out.
I don't like your driving. Get out.
Yep. Standard trooper. So when McCarty complied, Trooper Williams noticed that he was having difficulty standing. And then at that point,
what hour of the day was this? Did you say?
I did not say.
Not
Nope.
covered in the case brief?
No, sir.
Unbelievable.
Unbelievable.
The context matters,
Well,
Supreme Court.
I presume it's at nighttime, but I could be
You
wrong.
don't know.
I don't know. So at that point, quote, Williams concluded that McCarty would be charged with a traffic offense, and therefore his freedom to leave the scene was terminated, kind of, because he said,
Is that how he said it?
Yeah, I'm going to charge this dude with a traffic offense, right? However, McCarty was told that he would not be taken into custody. So then Trooper Williams asked him to perform a field sobriety test.
Mm-hmm.
Mr. McCarty didn't do so hot. So while still at the scene of the stop, Trooper Williams asked McCarty whether or not he'd been using intoxicants. And McCarty replied that, quote, he had consumed 2 beers and smoked several joints of marijuana.
Oh, they always say 2 beers.
A short time
the
before.
extra smoking 2 joints also is a nice
several.
topper.
It just says several. So that could be a number. But you're right. It's always 2 beers.
Always 2 beers.
Yep. Always. McCarty's speech was slurred, and Trooper Williams was having difficulty understanding him. So after that point, he formally placed him under arrest and transported him to the Franklin County Jail. At the jail, McCarty was given an intoxilizer test to determine the concentration of alcohol in his breath. And the test did not detect any alcohol whatsoever in McCarty's
So
system.
the beers were done.
Yep. Williams then resumed questioning McCarty in order to obtain information for inclusion in the State Highway Patrol alcohol influence report. McCarty...
The alcohol influence report that he's not under the influence of alcohol?
Right. Well,
interesting.
Yes. But remember, he smoked a lot of joints, too.
I know,
so
but that would be the marijuana influence report, not the alcohol influence
report.
They
have different names. I don't know.
That was also the context that mattered.
So in the midst of this additional questioning, he answered affirmatively to a question of whether or not he'd been drinking. And when he was asked if he was under the influence of alcohol, Mr. McCarty said, quote, I guess. Barely.
Did he see that he blew zeros?
Yeah, I don't know. Trooper Williams then asked him to indicate on the form whether the marijuana he had smoked had been treated with any chemicals. And in this section of the report, headed Remarks, Mr. McCarty wrote, No angel dust or PCP in the pot. Rick McCarty. Which is awesome.
He didn't ask him if it was certified organic.
No. He just said, no angel dust or PCP in there.
All right.
At no point in the sequence of events did Trooper Williams or anybody else tell McCarty that he had the right to remain silent, to consult with an attorney, or to have an attorney appointed for him if he could not afford one. Never happened. So McCarty was charged with operating a motor vehicle while under the influence of alcohol and or drugs. And under Ohio law, that offense is a first-degree misdemeanor. It's punishable by fine or imprisonment up to 6 months. And there can be an incarceration for a minimum of 3 days that is mandatory. So, believe it or not, Mr. McCarty moved to exclude the various incriminating statements he made to Trooper Williams on the grounds that introducing them into evidence would violate the Fifth Amendment, insofar as he had not been informed of his constitutional rights prior to that interrogation.
Yep, and he certainly was in custody when that occurred.
The trial court said, nah. And so Mr. McCarty pled no contest, and he was found guilty.
Interesting.
He was sentenced to 90 days in jail.
The trial court not know Miranda either?
Well, this one's an interesting one.
Okay.
Stay tuned. Mr. McCarty was sentenced to 90 days in jail, 80 of which were suspended, and he was fined $300 American, 100 of which was suspended.
Why? Why?
I don't know.
The suspension of time
it's hilarious.
Makes no sense to me.
So
just give him 10 days then.
Yeah, I know. Now, in applying the principle of Miranda to the facts of the case, the Court of Appeals, spoiler alert, he kept appealing.
Yep. Despite his no contest.
Right. The Court of Appeals distinguished between the statements made by McCarty before and after his formal arrest.
Yeah. Makes sense.
But they still upheld his conviction. So it went all the way up to the United States Supreme Court, and there were a couple arguments made along the way. One of those arguments was Miranda doesn't apply to misdemeanors.
Interesting.
Yeah. And the other question was, well, what about traffic stops? So the Court of Appeals divided it, right? The Court of Appeals said traffic stop questions are fine. The jailhouse questions, when he's super in custody, as you pointed out, not cool. So those are the two main questions in Berkmer v. McCarty. So the United States Supreme Court ruled that the severity of the crime does not change the requirement for constitutional protections during custodial interrogation.
So I'm pretty sure I didn't hear that part.
No.
They laid out a lot in section
there was
5
a lot
sections.
there was a lot of things. So the United States Supreme Court said a person subjected to custodial interrogation is entitled to the benefit of the procedural safeguards enunciated in Miranda, regardless of the nature or severity of the offense of which he is suspected or for which he was arrested. The court noted that creating an exception for misdemeanors, quote, would substantially undermine the rule's simplicity and clarity. The purposes of Miranda, which is protecting against coercion and relieving the inherently compelling pressures generated by the custodial setting, are implicated as much by in-custody questioning of persons suspected of misdemeanors as they are by questioning of suspects suspected of felonies. So they straight up said, doesn't matter. Doesn't matter the degree of offense.
Constitution still applies.
Correct. Yep. You still got to give these warnings during custodial interrogation. Now, the court then clarified that a standard traffic stop is generally not custodial for Miranda purposes. And they go into specific reasons why they do that. So, quote, the roadside questioning of a motorist detained pursuant for a routine traffic stop does not constitute custodial interrogation for the purposes of the Miranda rule. Ordinary traffic stops mitigate the danger that a person questioned will be induced, quote, to speak where he would not otherwise do so freely. They went on to say the detention of a motorist pursuant to a traffic stop lasts only a few minutes. A motorist,
depending on how quickly you are.
Well, right. But a motorist's expectations when he sees a policeman's lights and sirens or lights flashing behind him are that he will be obliged to spend a short period of time answering questions and waiting while the officer checks his license and registration, and that he may be given a citation, but in the end, he most likely will be allowed to continue on his way. So that is, you talked about it earlier, right? What is the expectation? What does a reasonable person in that position think? And the court said that's what a reasonable person thinks during...
Most people do not get arrested out of traffic stops.
Correct. So they're saying a reasonable person would say, hey, okay, I can't leave this second.
Yep.
But I'm going to leave at the end of this. The circumstances associated with a typical traffic stop are not such that the motorist feels completely at the mercy of the police. Now, to be sure, there's an aura of authority surrounding an armed uniformed officer and the knowledge that the officer has some sort of discretion, right, in deciding whether or not to issue a citation.
Yeah.
So that exerts some pressure on the detainee to respond to questions. But other aspects of the situation substantially offset those things, right? Perhaps most importantly, the traffic stop's in public. Remember how hard Miranda hammered home that custodial interrogations are done in private, right? That's the whole
incommunicado.
Oh man, there it is.
You're
Good word.
welcome.
So they're like traffic stops are out in the middle of public, right? So that's a big one, at least to some degree, right? So passerby on foot or in other cars witness the interaction of the officer and the motorist, and this exposure to public view both reduces the ability of an unscrupulous policeman to use illegitimate means to elicit self-incriminating statements and diminishes the motorist's fear that if he didn't cooperate, he will be subjected to abuse, right?
The third degree.
Yeah, well, thankfully
also,
that was long behind us.
Also a cut from last episode.
Yes.
If you didn't hear it or you missed that part, go back and watch it.
Yep. Yeah, man, that's a good point. You should probably start by watching the episode on Miranda, or else this one might not make a ton of sense.
That's the groundwork that's required, and you'll notice I'm quoting things because I watch these episodes so many times.
You do.
And it nails it home, so you should too.
Yep, good idea. All right. They went on to say that the fact that the detained motorist is typically confronted by only one or at most two policemen further mutes his sense of vulnerability. In short, the atmosphere surrounding an ordinary traffic stop is substantially less than police-dominated than the surrounding of the kinds of interrogations that Miranda was talking about, right?
Are you going to get to an episode where 3 or 4 cops show up to a traffic stop?
I don't think so. I'm not aware of any case law. Maybe we will. I don't know. However,
just in terms of, because they mentioned one, at most 2. We know that's
Yeah.
not necessarily the case.
Right. However, if a motorist is subjected to treatment that renders him, quote, in custody for practical purposes, then he is entitled to the protections prescribed by Miranda. So the court emphasized that an officer's private intentions do not need to trigger the warnings. Only the suspect's experience matters. So although
What would a reasonable person believe?
right, regardless of
Is that what they're hitting on this one?
regardless of what that officer's thinking, right?
Yeah.
So although Trooper Williams apparently decided as soon as he stepped out of his car, he's like, "Yep, this guy's getting charged with a traffic offense." Williams never communicated this to him. He never said,
You're definitely getting a ticket.
yes, or you're definitely getting arrested for OBI, right? He never communicated this plan. So, quote, a policeman's unarticulated plan has no bearing on the question whether a suspect was in custody at a particular time. No bearing. So even though that cop is planning on doing X, Y, or Z,
Yeah.
it is not judged from that.
Well, that plan would be evolving, so I don't know how you would hit the bullseye there.
That's the exact point, right? Because that
the probable cause is building throughout.
Correct. And it can disappear in an instant too, right?
Yeah, your observations are changing.
Yep. So whatever that officer is thinking at the time does not apply to whether or not that person is in custody at that time.
Also a dangerous game of trying to get into somebody's head.
Yeah. The only relevant inquiry is how a reasonable man in the suspect's position would have understood the situation, which is a very, very important quote.
Yep.
So, again, does Miranda apply to misdemeanors? Yeah, you better believe it does. Is a routine traffic stop custody? No. But if that traffic stop keeps evolving and it becomes custodial at any point, okay, now those protections that are afforded in Miranda v. Arizona apply. So, in this case, the initial pullover, not custodial. The roadside tests and conversations on the roadside, not custodial. Once he arrests him, takes him back to the station, those are totally in custody. And since he didn't Mirandize him, all those are not admissible. But everything
even though it's sweet written part
right.
about PCP and angel dust.
Yeah, I know. But so that's what they ruled. That's an important case. Again, we talked about it a little bit earlier, but you don't have to Mirandize every single person you come in contact to, right? The majority of traffic stops work out that way. Just know that if that traffic stop continues to evolve and now it becomes a custodial interrogation, you can't keep asking questions without Mirandizing that individual.
You need to recognize that.
Can't keep asking incriminating questions. That's important too. All right, man, you ready for the next case?
Number 4.
Yes, that feels right. All right.
If only you would number them so we would know.
Gosh, that is such a simple idea. I need to start doing that. All right, this case is Stansbury versus California, and this comes to us
back to California
in 1994, and it involves the arrest of Robert Edward Stansbury. Get ready to bleep. You ready? All right. So California police first questioned Stansbury as a possible witness to the and murder of a 10-year-old girl.
Oh, God.
Because they had another primary suspect. All right, details of this case.
He didn't participate, he just watched?
Well, no.
Oh.
So, however, Stansbury became a suspect during the interview when he told the police that on the night of the murder, he drove a car matching the one seen where the girl's body was found.
Whoops.
Then they're like, so that sent up a whole bunch of red flags for him, right? And then,
I just drove him there.
Then he admitted to prior convictions for, get ready to bleep, kidnapping and child molestation.
Sounds like that's all involved in this one, too.
Yeah. So at that point in time, they're like, okay, this is probably our dude. So they stopped the interview. They advised him of his rights under Miranda v. Arizona and arrested him. So the specifics, like it was pretty obvious. So there were two guys that were seen talking to this little girl on the night of her murder.
And where was she at?
In California. They were ice cream truck drivers. So two
That's even worse.
It gets worse. So two ice cream truck drivers had been seen talking to this little girl.
Turns out ice cream truck drivers talk to a lot of kids.
Yeah, one of them's Stansberry, and the other is another guy. And for some reason, I don't know why, and it doesn't delineate, but the officers suspected that the other guy was probably the one that did it. There was another witness that's where they found the body. They saw a big guy in a teal American-made sedan. So teal is pretty uncommon color.
Yeah.
And so they're in the midst of questioning this dude, and he admits to talking to her that night, right?
Did we cover how he got to this interrogation?
We will.
Okay.
Yeah. But we'll cover it now. They called him in, and they're like, "Hey, man, we think you might have been a witness to this crime. That's what's important. Is they pulled him in as a witness."
But allegedly, they actually believed that at that time.
Yeah, they did. They thought it was witness because for some reason they primarily suspected the other guy. So then they're chit chatting back and forth. He admits to talking to her, and then he says that night he drove his roommate's car. And they're like, what kind of car does he have? And he's like, well, he's got a big teal American sedan.
Ooh.
And they're like, oh, you got any prior convictions? And he's like, all of them.
You ever been arrested before? I love that question.
Yeah, and he's like, yeah, all of them that apply to this crime. And they're like, all right. So that's when they pump the brakes.
Thank you, California, for letting him out.
Yeah, they pumped the brakes. They advised him of his Miranda rights, and they arrested him. So the trial court.
It? No more questioning after that?
No, not that's debated here. So the trial court denied his pretrial motion to suppress his statements to the police, reasoning that he was not in custody for purposes of Miranda until the officers began to suspect him. He was convicted of all of the crimes, and he was sentenced to death. In affirming, the state Supreme Court concluded that one of the relevant factors in determining whether or not he was in custody was whether or not the investigation was focused on him. So that's what the state Supreme Court said, agreeing that the suspicion focused only on him after he mentioned the car. And the court found that Miranda did not bar the admission of statements made before that point. So it continues to get appealed all the way up to the United States Supreme Court, and they grant.
Certiorari.
They sure do. All right. What do you think they said for this?
I was looking for more context as that. So they just called him in, and he willingly came in.
Yeah, they're like, hey, man, we think you might have been a witness to this crime. We're investigating the death of this 10-year-old little girl. We think you might be a witness. Can you come in and talk to us? And he did.
And then in this interrogation room, there was no statements as to you're free to leave, you're not free to leave, anything that is not covered.
None of that is covered. So, all right, let me clarify a little bit here. So, they contacted Stansberry to see if he would come in for questioning as a potential witness. So, several other plainclothes officers arrived at his home at 11 p.m. in the evening. They knocked, and he answered. And they said, hey, man, we are investigating a homicide that you were a possible witness to. Do you mind coming back to the police station to answer some questions? So he's like, yeah, sure.
Voluntary.
He agreed to the interview and accepted a ride to the station in the front seat of the car.
That is a factor.
So at the station, 2 different officers were present, and they questioned him about his whereabouts and activities during the afternoon and evening of the date in question. Stanberry told the officers that he had spoke with the victim and returned to his house at 9 p.m. and he left his house about midnight in his housemate's turquoise American car. That last detail aroused his suspicions as the turquoise car matched the description of the suspect vehicle that one of the witnesses had observed. And so they went to his house, but he voluntarily agreed to go back, sat in the front seat, all of that. Do you think he was in custody?
No.
You are correct. All right. So the court emphasized, because we just talked about this, that an officer's secret intent or suspicion does not change the legal status of an interrogation.
Their intent changed in this one.
Correct. It changed right in the middle.
Yeah.
And they're like, oh, geez. Quote, we hold that an officer's subjective and undisclosed view concerning whether the person being interrogated is a suspect is irrelevant to the assessment of whether or not that person is in custody. So it's the same thing they said before, right? Doesn't matter. as save as they are communicated or otherwise manifested to the person being questioned, an officer's evolving but unarticulated suspicions do not affect the objective circumstances and thus cannot affect the Miranda custody inquiry.
They keep saying unarticulated. So if you were talking to them about it,
It would change it, right? Think about it though, because if this
you
guy,
seem pretty guilty.
yeah,
I'm thinking I'm developing probable cause to arrest
right,
you right now.
yeah,
That would change
it would change
because
it.
you would be telling them they're no longer
Exactly.
free to leave.
Exactly, right? Because a reasonable person would think, oh crap, they
no.
know I did it. I can't leave now. Right?
Not just your fingerprints were found there. But,
Yes.
man, my probable cause meter is off the charts right
Yeah.
now.
The court noted that, quote, the threat to a citizen's Fifth Amendment rights that Miranda was designed to neutralize has little to do with the strength of an interrogating officer's suspicions. So they're really beating that to death. Doesn't matter what the cop's thinking at that point in time. It is a reasonable person standard. So the test is based on the perspective of a neutral observer, right? A reasonable person. Quote, the initial determination of custody depends on the objective circumstances of the interrogation, not on the subjective views harbored by either the interrogating officers or the person being questioned. As established in Berkmer v. McCarty, see how these build?
Yep.
The only relevant inquiry is how a reasonable man in the suspect's position would have understood his situation.
Which was voluntary as far as we were briefed.
100%. Yeah. The court
And
noted
rebriefed.
that an officer's belief only matters if it is expressed in a way that changes the physical or psychological environment. So that's exactly what you were just talking about, right? An officer's knowledge or beliefs may bear upon the custody issue if they're conveyed by word or deed to the individual being questioned.
Written down?
Handcuffing him?
Well, you said
Yeah, the officers.
word or deed.
Yeah, if the officer's knowledge and his beliefs are conveyed by word or deed, right? So if I get on the radio and I call in 8 more people and 8 dudes walking in the room and they slam the door, and now we're all sitting out here, that's a deed, right? That would change the dynamic, right? So if that happens, then sure, okay, but it's important to say, quote, even a clear statement from an officer that the person under interrogation is a prime suspect or not in itself is not dispositive, but it may be a factor in the custody determination if it would affect how a reasonable person in that position would perceive his or her freedom to leave.
Yep.
So even I can even tell you, hey man, you might be the suspect, but I'm still investigating this case, right? That if that dude came there voluntarily and he still feels like he can get up and walk out, then it's not custody. The court explicitly rejected the idea that Miranda is triggered simply because a police investigation has focused on a specific person, which is very important to know. The court found that the California Supreme Court's focus on whether or not the investigation has focused on that person, they found that incorrect.
Yeah.
The mere fact that an investigation is focused on a suspect does not trigger the need for Miranda warnings in a non-custodial setting. So they said, yeah, this one's good to go. It was all voluntary. He voluntarily agreed to come to the police station. 2 dudes were talking to him. Nothing about that situation indicated that it was a custodial interrogation at that point in time. So everything was admitted.
Did he have an accomplice for this?
No, just
him.
Just him. Yep. That one's got some terrible details, which I skipped.
I want to say if he left at midnight.
Yeah.
So can't imagine she was still getting ice cream at midnight in the streets of California.
Yeah, he said he had talked to her at like 6 p.m. Then he left and went home at 9 p.m. And he had left his residence thereafter. But all right, you ready for the next one, man?
Number 5.
Number 5. No idea how to pronounce this guy's name, but I'm going to try. All right. This is the case of Thompson v. Keohane is what I'm going with. Keohane. Keohane? Keohane?
Yeah.
Keohane. That's what we're going with. This case comes to us from 1995. It involves the arrest of Carl Thompson, thank goodness, not the other guy, for the murder of his former wife. So
Ex-wife.
Yes. Well, yes.
We don't know if they're divorced.
Yeah, correct. Former wife.
Former wife.
Is what they keep saying.
Is it former because she's dead?
That is part of it.
Mm.
Yeah. All right, you ready? All right. So this in September of 1986, two moose hunters discovered the body of a dead woman floating in a gravel pit lake on the outskirts of Fairbanks, Alaska.
Floated.
Yeah.
Hmm.
The woman had been stabbed 29 times.
It's a lot of times.
So the two hunters that found her notified the Alaska State Troopers, and they go and start their investigation. In the midst of their investigation, they issue a press release seeking for assistance in identifying the body because they had no idea who the decedent was. Thompson called the troopers, and he informed them, hey, my former wife, Dixie Thompson, fits that description in the press release, and she's been missing for about a month.
Did he report her missing? Or did anyone report her missing?
Does not cover that. But when he called, he said, hey, she's been missing for about a month, and she fits that description that you put out in that press release.
I'm very concerned about her.
So with that information, they do a dental examination, and they were able to conclusively establish that the corpse was Dixie Thompson.
I'd love to know why he decided to call.
Who knows? How many Forensic Files episodes
No.
happen with that exact thing where they're like, you know what, I'm going to get out in front of this.
Yep.
Nope.
Get out in front of you being the prime suspect.
Yeah, exactly, right? So 4 days later, a trooper calls Thompson and asks him to come into the headquarters, purportedly to identify personal items that the troopers thought belonged to Dixie Thompson. So they're like, hey, man.
That seems reasonable.
So they're like, hey, man, you mind coming in here?
You know what her stuff looks like.
Yep. Now, it is now undisputed, now at the time of the writing of this case, that the trooper's primary reason for contacting Thompson was to question him about the murder. So Thompson, on his own, drives to the trooper's headquarters in his pickup truck. And he shows up, he looks at the items, and he's like, yeah, those are definitely Dixie Thompson's. He remained at the headquarters for 2 more hours. And 2 unarmed troopers continuously
Unarmed?
I know, it points that out. It's interesting, right? Continuously questioned him in a small interview room, and they tape recorded the exchange.
Mm-hmm.
The troopers did not inform Thompson of his Miranda rights. They constantly assured Thompson that he was free to leave, but they also told him repeatedly that they knew he killed his former wife. They then told him that an execution of a search warrant was underway at his home and that his truck was about to be searched pursuant to another search warrant. And the troopers asked questions.
I don't know where they get all this at. Probable cause for these search warrants already.
I don't know. But they tell him these things, right? And they continue to ask him questions that invited a confession. So eventually he admits to the troopers, yes, I killed Dixie. So he first attempted to appeal the ruling that he was not in police custody. So the trial court said, yeah, you're not in police custody. The Alaska Court of Appeals upheld the ruling of the trial court, and the Alaska Supreme Court decided not to hear the case. So this case is
They did not grant certiorari.
I don't know if state Supreme Courts do that. I guess it would probably be the same term, right?
Why wouldn't it be?
Yeah.
To be more fully informed.
Yeah. Look at you. You're learning all kinds of stuff, dude. All right. This case is a little bit different. There is the majority of this case focuses on something that's not super applicable to cops or the average citizen. So I'm going to blitz through that real quick. But then the case establishes.
Sure seemed like it applied.
Well, the court then establishes a really important thing. So blitz through the other things real quick. So Thompson, filed in the United States District Court for the District of Alaska. And that court deferred the judgment of the state courts under 28 United States Code 2254D, which states that in most circumstances, questions of fact are presumed correct by the Court of Appeals. So they're saying this is a state court problem to determine custody, whether or not somebody's in custody. That's why the Supreme Court gets involved. So the Court of Appeals for the Ninth Circuit affirmed the district court's ruling without publishing an opinion. So they again said, hey, because of this United States code, this is the state's problem to figure out whether or not a person is in custody. It is not up to the higher courts. And the United States Supreme Court said, nah, 28 USC 2254D does not apply in custody rulings for the purposes of Miranda because it's a constitutional issue. So they're saying, hey, each step of the appeals process has to reevaluate whether or not this person is in custody. You can't just de facto take whatever the state decides. So that's the majority of this case.
Do your job.
Yep. So the court found that the question of custody for Miranda purposes was a mixed question of both fact and law. So because of that, this can absolutely be held by federal courts. So the case was remanded back to the Ninth Circuit, and they instructed them to decide whether or not Thompson was in custody at the time of the questions. But in the midst of doing all of that, so again, not really applicable to the police, but in the midst of doing all of that, they created, or outlined rather, a two-pronged inquiry.
We love making prong tests.
Yep, two-pronged inquiry for whether or not somebody is in custody. So the court defined the specific analysis required to determine if a person is in custody. So they're like, well, if we're going to remand this back, we got to make sure that they're on the right track, right? So
because we don't want to mess with this case again.
Correct. So here's the two things, Ninth Circuit, that you are going to look for in determining whether or not Mr. Thompson was in custody. One is the factual component. So two discrete inquiries are essential to the determination. First, what were the circumstances surrounding the interrogations? What we've already talked about all these times, right? Secondly, given those circumstances, would a reasonable person have felt that he or she was not at liberty to terminate the interrogation and leave? So boom, there's a two-part test. It is the circumstances surrounding the interrogation and whether or not a person is free to leave. So it's a mixed question, right? So the second inquiry, right, whether or not somebody is free to leave, calls for the application of controlling legal standard to the historical facts and thus presents a mixed question of law and fact, qualifying for independent review. Once the historical facts are resolved, the state court is not in an appreciably better position than the federal court to make the ultimate determination. So they're saying the federal court can do this. So they sent it back down. So two-prong test. That's what you need to hear from that. And the second prong comes directly from Berkmer B. McCarthy. All right, David, you ready for the next case?
Number 6.
I think 6.
0.9.
All right. So this case is JDB v. North Carolina, and it's JDB because it involves a juvenile. So we don't know his whole name. JDB, John David Boy. I don't think that's his name. But JDB, I'll call him JDB. I'll call him JB. I'll call him J. I'll call him the juvenile. Whatever. It's a juvenile, so we don't have his full name. Versus North Carolina. And this case comes from 2011.
Wow.
I know you like the recent cases.
Almost present.
All right. So in this case, the Supreme Court held that a child's age is a relevant factor in the Miranda custody analysis. The decision modified the traditionally objective reasonable person test to account for the unique vulnerabilities of the youth.
Oh, boy, and how intelligent they are.
Mm-hmm. So JDB was a 13-year-old 7th grade middle school student, and he was removed from his classroom by a uniformed police officer, SRO, and he was escorted to a closed-door conference room where he was questioned by police for at least half an hour. So this was the second time that police had questioned this kid in a span of a week. So several days.
Sounds like he's on a bad track.
Yeah, he is. He's burgling.
Nah.
Several days earlier, there were 2 different home break-ins and all kinds of stuff was stolen. And at the time, the police had stopped and questioned this kid when he was seen behind a residence in the neighborhood where the crimes had occurred. And they talked to his grandma, who was his legal guardian, and they also talked to his aunt that day. Police later learned that a digital camera matching the description of one of the stolen items had been found at his middle school and was seen in his possession.
Whoops.
So they had already talked about him.
Don't bring your toys.
Yeah, right. So now they need to question him about the camera, which is why he's questioned a second time at the school.
You got a receipt for that?
So the investigator with the local police who had been assigned to the case went to the school to question him. He meets with the school resource officer and the assistant principal and an administrative intern. And
administrative intern.
Yeah, he told all of them, hey, I'm here to talk to JDB about these burglaries. And
he said, that's cool.
Yep.
He doesn't pay attention in math anyway.
Yep. So he asked the school administrators to verify his date of birth, his address, and parent contact information from the school records, but neither the police nor the school admin contacted JDB's grandma. So they interrupted his social studies class, removed him from the classroom, and escorted him to a school conference room. And there, so we have the investigator, the SRO, the assistant principal, and then the administrative intern. The door to the conference room was closed, and he was questioned for the next 30 to 45 minutes. He wasn't given Miranda warnings, wasn't given the opportunity to call grandma.
Or a lawyer.
And he was not informed that he was free to leave the room. So they start off with small talk, and then eventually they get into all the burglary events.
Mm-hmm.
He denied any wrongdoing. He explained that he had been in the neighborhood where the crimes occurred because he was seeking work to mow lawns. And
little businessman.
Yeah. But they keep pushing him, and eventually they confronted him with a stolen camera. And the assistant principal urged him to, quote, do the right thing, warning JDB that, quote, the truth always comes out in the end. So eventually, old JDB is like, hey, am I still going to be in trouble if I return the stuff? And they're like, well, that could be helpful, but, quote, this thing's going to court regardless.
Interesting.
So that's what they told him. So they also told the kid.
No one wants to press charges. They just want their stuff back.
So they then told the kid, the investigator told the kid that he may need to seek a secure custody order because he's like, look, man, if you're going to continue to break into homes, I might get you held in a juvenile detention center.
Yeah.
So
seems like he's a serial
burglar. The investigator explained that, hey, that's where you get sent to a juvenile detention before the court.
Yep.
And then once they told him that, JDB's like, all right, man, it was me. Me and a friend.
I don't want to go to the detention center. I swear I'll stop.
Exactly. Me and a friend were responsible for the break-ins. So then after he says that, then the investigator says, hey, you can refuse to answer my questions and you're free to leave after that. So they asked him if he understood, and he's like, yeah, I understand. So then juvenile provides a whole lot more detail, including information about the location of the stolen items. He writes a statement. A bell rang indicating the end of the school day, and they said, all right, off you go. They sent him on his way. So 2 juvenile petitions were filed against JDB.
They didn't send him to Principal Shaq Hennessy's office.
No.
You know what you did.
Each alleging 1 count of breaking and entering and 1 count of larceny.
That's it?
Yeah, that was it. So they goes through the appeal process all the way up to the United States Supreme Court. Because the question was whether or not his age plays into a factor, right? Because nothing about that is custodial. Would you agree for the most part? I mean,
other than like you're not really.
If you were an adult, if they pull a teacher into a conference room,
no, that'd be a different story because the kid has to kind of be at school.
Okay, right.
So that would be a little bit different.
Exactly. So, but they pull in one of the teachers and they're like, hey, can we talk to you for a minute? They go into a conference room, they talk for a while, and they're asking questions. That teacher would likely feel free to get up and just quit. Like, no, I'm going back to my classroom, or I'm going home, or I'm doing whatever, right? So the question is, does the kid feel the same way? So the Supreme Court held that courts cannot ignore the common sense reality that children perceive police encounters differently than adults. Quote, it is beyond dispute that children will often feel bound to submit to police questioning when an adult in the same circumstances would feel free to leave.
Because the children don't watch Cuffs and Case Law podcasts, and they should.
Seeing no reason for police officers or courts to blind themselves to that common sense reality, we hold that a child's age properly informs the Miranda custody analysis. So they kind of created a, quote, reasonable child standard. So long as the child's age was known to the officer at the time of questioning, or would have been objectively
reckless in that regard,
or would have been objectively apparent to any reasonable officer, its inclusion in the custody analysis is consistent with the objective nature of that test. So they go on.
A child's maturity based on age is a rough.
What did you hear that? Did you hear what he said, dear listener?
Mm.
Listen to what I'm going to say. The court emphasized that children lack the maturity and judgment of adults, making them more susceptible to the pressures of an interrogation. They're
I was
generally
making the point that their age and their maturity are not
they're not the same
equal
thing, right? And that's what they're saying, right?
of each child.
Correct. So, spoiler alert: this is remanded back down because they're like, we can't determine whether or not this kid was in custody because we don't know what this kid's maturity level is. We don't know what his level of understanding
You
is.
guys didn't find those facts?
Yep, exactly. Children are generally less mature and responsible than adults. They often lack the
Or
experience.
sometimes they're more.
Yes, also true. They often lack the experience, perspective, and judgment to recognize and avoid choices that would be detrimental to them.
By the way, did you wear the same watch you wore in Miranda?
No,
it
this
looks
is a different one.
similar.
I know, but this is a different one. Thank you for pointing it out. You're
Yep.
getting really good at that.
Well, I saw it in the back of the camera lens actually, and was
nice.
like, that one looks the same.
No.
What does that one do?
This one tells the time.
Does it tell you if you're in custody or not?
No, it doesn't.
No, that'd be a cool watch.
No.
Everyone should
Although I'm
invest in
not
that.
wearing a handcuff on that wrist, so that is a clue.
That is a clue.
The court in this specific case also noted that questioning a kid at school, to your point, adds a layer of compulsion, right? A student whose presence at school itself is compulsory, he has to be there, and whose participation at school events is routinely supervised and controlled by the school authorities is not free to leave in the same sense as an adult. So exactly what we talked about, right? And the Justice Sotomayor, who wrote the opinion for the Supreme Court here, argued that, hey, including age in this does not make the test subjective or overly difficult for the police to apply, right? Just understand that kids are different than adults. So age matters, location matters, judged from the perspective of a reasonable child. And they said, look, hey, the question remains whether or not he was in custody when the police had interrogated him. So we remand it back to the state courts to address that question, taking account of all of the things that we just pointed out, right? All of the relevant circumstances of the interrogation and his age at the time. So they remanded it back to the Supreme Court.
I don't think they would have loved that.
No. All right, man. You ready for the next one?
Number 7.
This is it. This
the
is the last,
finish line.
The
has
last
arrived.
one we're covering
all
today.
of you who are making it through here.
And thank goodness this one has easy to pronounce names. This is the case of Howes versus Fields from 2012. So again, another relatively recent case. So old Randall Fields was serving a sentence in a Michigan jail.
Okay.
And he was escorted by a corrections officer to a conference room where 2 sheriff's deputies questioned him about allegations that before he came to prison, he had engaged in sexual conduct with a 12-year-old boy. He arrived at the conference room between 7 p.m. and 9 p.m., and he was questioned for between 5 and 7 hours.
That's a lot of hours.
It is. But at the beginning of the interview, he was told that he was free to leave and return to his cell.
That's I can imagine the Supreme Court saying that is a very high bar for you to say when someone is in prison.
Very interesting, right? Later, he was again told during the interview that he could leave whenever he wanted. So the 2 interviewing deputies were armed during the interview. So again, they point that out. But Fields remained free of handcuffs, didn't have any other restraints. The door to the conference room was sometimes open, sometimes shut, just based on what else was going on in the prison at the time. About halfway through the interview, Fields had been confronted with the allegations of abuse, right? He got angry. He became agitated and started to yell. And that one of the deputies, using an expletive, told him to sit down and said, quote, "If you don't want to cooperate, you can leave." So
that's kind of contradictory to sit down.
Well, he's getting rambunctious, right? So for good order of the jail, right? He's like, sit down. If you don't want to do this, you can leave. If you don't want to cooperate, you
if
can
those
leave.
2 things are together.
Yes.
Then
so eventually, he confessed to the crimes against the boy. And according to his testimony at the suppression hearing, he had said several times during the interview that he no longer wanted to talk to the deputies. But he did not ask to go back to his cell prior to the end of the interview. When he was eventually ready to leave, he had to wait an additional 20 minutes, right? So a corrections officer had to be summoned to escort him back to his cell, and he didn't return to his cell until well after the hour when he was supposed to usually go back to his cell and go to bed, right? At no time would he given Miranda warnings or advised that he did not have to speak with the deputies other than specifically saying, look, dude, if you don't want to cooperate, you can leave. And they told him multiple times that
you can go.
You can go. He was charged with criminal sexual misconduct, and he was convicted. And so, again, just like the rest of these, it works its way all the way to the United States Supreme Court. What do you think they said? It's an interesting one, right?
Yeah, you're free to leave in a prison.
Mm-hmm. It's essentially what the question is.
Given the context that he's not handcuffed, the door's open or closed, he's told repeatedly, you can leave. I would say the Supreme Court would say, you're all right.
Gosh dang, you are very good. Look at you putting
Context
all the pieces
matters.
together. Context matters. You nailed it.
Despite being in the prison.
The Supreme Court clarified that an inmate's imprisonment does not automatically mean they are in custody for Miranda purposes when questioned about outside crimes. The court rejected the categorical rule that isolation and questioning about events outside the prison wall always trigger Miranda protections. So
you can't just blindly apply these rules. That's why you need to pay attention to Cuffs and Case Law podcast.
Exactly. Service of a prison term without more is not enough to constitute Miranda custody. Our precedents do not clearly establish the categorical rule that the questioning of a prisoner is always custodial when the prisoner is removed from the general prison population and questioned about events that occurred outside. Questioning a person who is already in prison does not generally involve the shock that very often accompanies an arrest.
Because they're already used to it.
They're already there, right?
What are you going to do, put me in prison?
Yeah. So the court emphasized that the standard freedom of movement test must be adapted to the prison environment.
Which he was told repeatedly he had freedom of movement.
Yeah, he could go back to his cell
whenever he wanted to. Was not physically
prevented.
prevented.
Exactly, right? So the initial step is to ascertain, given all of the circumstances surrounding the interrogation, how a suspect would have gauged his freedom of movement.
Mm-hmm.
So, again, are they free to leave? Obviously, they can't leave the prison, but are they free to leave that interrogation? That's what they said. So the ultimate inquiry is simply whether there was a formal arrest or restraint on freedom of movement of the degree associated with a formal arrest for what you're questioning about. And you have to apply that to the prison setting, right? A person who is cut off from his normal and environmental changes may feel a sense of isolation, but a prisoner, in contrast, is already living in a restricted environment. He's unlikely to be lured into speaking by a longing for a prompt release, right? He's already in prison because he knows that when the interrogation ends, he's going back to his cell, regardless.
Double prison.
A prisoner knows that his questioners probably lack the authority to affect the duration of his current sentence because he's already sentenced.
Yeah.
So, yeah. So they said, hey, look, when somebody's in prison, you have to judge it from their normal freedom of movement within the prison. And they specifically put that in contradiction to the Orozco and Stansbury cases, right? So in Orozco and Stansbury, right, the deprivation of freedom of action is the main thing. In the prison context, it's restraint beyond a normal prison life. As far as location, in Orozco and Stansbury, police-dominated atmosphere is key, right? In the prison context, private rooms may actually be more supportive to the individual, right? And one of the key factors in Orozco and Stansbury is being told you're under arrest, right? In the prison context, it's being told you can go back to your cell, right? All important things to point that out. So that is all 7 cases, man. And
very important application, though.
Yes, very important application. And because, again, Miranda, everybody gets Miranda, but if you don't know exactly when to apply it, it loses all purpose. So context matters. And one of the most important factor in determining whether or not you have to Mirandize somebody is whether or not they're in custody, because the interrogation part is easy. I know if I'm asking you questions that are likely to elicit an incriminating response, right? That part's easy. But are you in custody is the question. And so these 7 cases should give you a really good understanding of whether or not somebody's in custody. To summarize them, right, I made some bullet points for you here.
Ooh.
You are probably in custody. Probably in custody if movement is physically restrained. So if you're in handcuffs or you're in a locked room or something like that, it's probably in custody. If the environment is police dominated, so if there's 4 cops in your bedroom at 4 a.m., you're probably considered in custody for Miranda. If the person is specifically told they're not free to leave,
That'll do it.
they're probably in custody, right? And they're definitely in custody if a reasonable person would think they're not going anywhere and they're not allowed to go anywhere, right? Conversely, you're probably not in custody when it's voluntary, right? When you drive to the police station yourself or you agree to meet an officer at some shopping center. You're probably not in custody if the duration is short and there's a light at the end of the tunnel, right? Which a reasonable person would think is,
which you wouldn't know at the time,
right? But I'm saying, like, even if right in this second, yeah, I'm not free to go. Think about the traffic stop, right? Yeah, when I get stopped by a cop, I'm not right now free to go, but I usually my brain tells me that in 5, 10, 15 minutes I'm going to be on my way.
Yeah.
So short duration, minimal restraint, right? So if you're not handcuffed, I think that's why they kept putting in whether or not the officers were armed too, because
the presence of a gun.
Yeah, presence of a gun, right? It's that authority thing, right? Police dominated, I guess. But if you're not handcuffed, if you're the door to the room that you're being questioned in is opened, right? If you don't need key card access to get out of whatever building you're into, all of those factors play in.
Because the context matters.
Correct. And you're definitely not in custody if it is clear that you can leave at any point in time.
And you're repeatedly told that.
Yes. So again, this is determined by the circumstances. All of the circumstances, whether or not a reasonable person would think they're free to leave, and then we got to throw in age. So those are the factors, man. And that's all I got. That's all I got for determining on whether or not a person is in custody. It's important. You guys need to know this. Both my police officers out there and my citizens. I want you to know. Because Miranda, again, is one of those ones that a lot of people think they know, and a lot of people are wrong. So it's important for me.
Lean on needing it all the time, or thinking that anytime the police talk to you, you need to be Mirandized or none of it counts.
Exactly, and that is just not the truth, right? It's custodial interrogation, and hopefully this episode painted a better picture and gave you a more complete understanding of the relevant factors in determining whether or not that individual is in custody at the time of the interrogation.
So if you learned something, please subscribe, tell your friends. Let others know about this content so they can be more fully informed.
Oh, man, that's good. All right. You got anything else for him, David?
I don't.
All right.
Drink more water.
Yep.
Hydration is important.
It is. And consistency is 80% of the equation. So when it comes to physical fitness, 80% is consistency.
And then you're going to leave the other 20% for the next episode.
You'll find out. Tune into the next episode of Cuffs and Case Law. Thanks, guys. Thanks for watching. When is somebody in custody for the purpose? I already said the F word. Just started. Dang it, dude.